Marquise Cox.
He is in custody, Your Honor. Casey Etheridge for Marquise Cox, Your Honor, and we would be entering a not guilty plea for today and setting this for the next pretrial conference date, which would be December 28th.
All right, December 28th at 9 a.m. for Mr. Cox. Jonathan Davis.
See you. Casey Etheridge for Jonathan Davis, and Your Honor, we'd be entering a plea of not guilty for today and setting this for the next pretrial conference, December 28th.
All right, December 28th at 9 a.m. Do you want any time to file pre-arraignment motions?
Yes, Your Honor, I apologize, yes.
All right, I'll give you 15 days to do that.
Thank you.
Christelle Gifford. Are you Ms.
Your Honor,
Gifford?
Casey Etheridge for Christelle Gifford, Your Honor, and we'd be entering a plea of not guilty for today and setting this for the pretrial conference, December 27th.
All right, December 27th at 9 a.m. and you'll be back in court those dates and time, ma'am. You need to stay in contact with your attorney. That's a condition of your bond. Ashley Mayan Oviedo. You, Miss Oviedo? You have an attorney, ma'am? You understand that you've been charged with a criminal offense. It's a felony, carries a maximum penalty of 5 years state prison, $5,000 fine, or both. Did you want to be represented by an attorney? If you can't afford one, the court will appoint one for you. You're going to hire your own attorney?
No, can I get one appointed?
Pardon me?
Can I get one appointed to me?
Oh, can you get one appointed? Does she qualify? Has she filled out an affidavit?
We have an application we can give her, Your Honor.
You do? Okay. I'll go ahead and appoint. Ma'am, do you have any income at all? Have any money in any savings or checking accounts? Any assets at all from which to hire your own attorney?
No, sir.
All right, you'll be required to fill out that affidavit, ma'am, but it sounds like you are indigent, so I'll go ahead and appoint the public defender to represent you.
Circle yes or no. Clerk's office downstairs.
Wait, I know.
And is she, I'm sorry, is she on a pretrial date already, Your Honor?
Well, if you enter a plea of not guilty, I'm going to put her on for the 27th. Is
That's perfect, thank you.
that what you're going to do?
Yeah, she's going to plead not guilty this morning.
All right. She'll be on the docket then for December 27th at 9 a.m. Ma'am, you need to come back to court that date and time. Stay in touch with your attorney. Those are conditions of your bond.
Thank you.
Terry McMullen. All right, you Terry McMullen?
Yes, sir.
Ms. McMullen, you've been charged with, looks like possession of a controlled substance without a prescription and also possession of drug paraphernalia. The first one is a felony, second one is a misdemeanor. Do you want to be represented by an attorney? If you can't afford an attorney, the court will appoint one for you.
Yeah, I can't afford one.
Do you have any assets at all from which to hire an attorney?
I own a car, that's it.
You'll need to fill out an affidavit with regard to your financial situation, but it sounds like you're indigent, so I'll go ahead and appoint the public defender to represent you, sir. You'll have, your next court appearance will be, well, I presume he's entering a plea not guilty?
Yes, sir.
If I could have a moment, Your Honor. Your Honor, we'll enter a not guilty plea and leave this set for pretrial.
All right, December 27th at 9 a.m. Sir, you need to be back in court that date and time. You need to stay in touch with your attorney. Those are conditions of your bond.
Thank you, Your Honor.
Angela Rushing,
As soon as you can. Your Honor, Tim Gibbs on behalf of Angela Rushing, 22 CF 2809. We're here for arraignment. Ms. Rushing is going to enter a not guilty plea this morning. We'll leave this set for pretrial 1227.
all right, ma'am, you need to be back in court December 27th at 9 a.m. And you need to stay in touch with your attorney. Those are conditions of your bond.
Giving her a card now, Your Honor.
Okay? Russell, we took care of this morning. William Schumpert.
Yeah, give me a call.
William Schumpert or Schubert? Oh, is he in jail?
He's an inmate, Your Honor. Your Honor, Tim Gibbs on behalf of William Schumpert, 22 CF 2831. We're entering a not guilty plea this morning. We'll track this. He has another new law case, 22 CF 1091. Leave that set for pretrial 1228.
1228.
Yes, Your Honor. Request 15 days to file any pre-arraignment motions.
All right, I'll grant that motion, and we'll set this for December 28th at 9 a.m.
And Judge, may I inquire with Madam Clerk, maybe could help? These recently that have been set for 12/27, my court docket indicates these are set for pretrial on 2/27, February. Okay, I was just making sure.
But
It's not February 27th,
Is 1091 already on December 27th?
no.
Both on February.
Oh, wow.
22 CF 1091 is his other case number. 1228 is perfect.
But the ones prior were on February 27th.
But the older one was already on December 27th.
Okay, we can leave it on the December. That's fine.
All right, so let's put both his cases on for December 28th. He's incarcerated.
Either that day or
It says the 27th, but let's do the 28th at 9 a.m. Zachary Ward. You, Mr. Ward?
Yes, sir.
All right, sir, you've been charged with 3 counts by information. Count 1 charges possession of controlled substance without a prescription. Count 2 charges possession of legend drug without a prescription. Count 3 charges possession of narcotic equipment. Count 1 is a felony. What about legend drug? Is that a felony or a misdemeanor?
That's going to be a misdemeanor, Your Honor.
So count 1 is a felony, and then you've got 2 misdemeanors.
Yes, sir.
Serious charges, sir. Do you want to be represented by an attorney? If you can't afford an attorney, the court will appoint one for you.
Yes, sir.
Have any source of income from which to hire an attorney?
No, I haven't been working here lately. I got hurt.
Have any money in savings or checking accounts? All right, you'll need to fill out a financial affidavit. There's still a $50 fee.
With that, Your Honor, we'll enter a not guilty plea, leave this set for the next pretrial.
And this is, I have February 27th on this one as well.
Already on 12, that's fine.
Yeah, February 27th.
If it's already on there, that's
I
fine.
was assuming that was a typo. Is it February 27th or is it 12/20?
Yeah,
February 27th?
so we have a pretrial date coming up December 27th and 28th, and then the next one after that that's scheduled is February.
Okay, so this one should be on for February then.
I believe it's already scheduled for that date.
All right, February 27th at 9 a.m. Sir, you need to be back in court that date and time. You need to stay in touch with the attorney. That's a condition of your bond.
Yes, sir.
got the add-on, Leanna Breyer, is that right?
Yes, Your Honor.
Were they able to transport her? I know that was a
Yeah,
question.
she's,
They were? Okay.
Casey Etheridge from Ms. Breyer. We're here in 22 CF 2900. And Ms. Breyer would like to enter a no contest plea and accept the state's offer. Would you like me to read the sentence out, Your Honor, or would you just like me to give it to the court?
You can give it to me if it's written
Okay,
down.
yes.
Has she reviewed?
She's about to sign it right now, yes. May I approach, Your Honor? Oh, sorry.
All right, ma'am, would you raise your right hand and be sworn, please? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? And what is your name? And Ms. Breyer, I have a written plea agreement. It's dated today. Has what purports to be your signature. Is that your signature?
Yes, sir.
Prior to signing this, did you read it?
Yes, sir.
Did your attorney go over it with you? Do you have any questions about it this afternoon? You satisfied you've had sufficient time to discuss the case and any theories of defense to these charges with your attorney?
Yes, sir.
Are you satisfied with the services of your attorney? Has anybody forced, coerced, or threatened you to sign this written plea or enter a plea this afternoon? Have you had any drugs or alcohol within the last 24 hours? What you tell me is you're entering this plea freely and voluntarily of your own will, is that right? And she's pleading no contendere to all 4 counts?
Yes, Your Honor.
All right, the court's going to find that the plea of no contendere, case number 22 CF 2900, all 4 counts is freely, voluntarily, intelligently entered after defendants had the benefit of advice of counsel. The court will accept the plea. At this time, I'll withhold the adjudication on all 4 counts. On counts 1 and 2 shall be placed on probation for a period of 3 years with the following special terms and conditions. She'll be required to pay $515 in court cost, $100 cost of prosecution, $150 in a public defender fee. She'll be required to undergo a substance abuse evaluation and follow through with any recommended treatment. And she'll be required to enroll with that let me rephrase that. She'll be required to be evaluated within the first 60 days of her release from custody. She's not to be in the possession of or use any controlled substances without a valid doctor's prescription. She'll be subject to random testing at her own expense. She'll be required to perform 100 hours community service work at the rate of no less than 5 hours per month. She's not to have any contact in any way whatsoever, direct or indirect, with Carolyn Snyder, and she's not to be upon the property located at 5501 Buckward Road in Baker, Florida. And the court will reserve jurisdiction she'll be required to make restitution. The court will reserve jurisdiction for a period of 90 days for that purpose. That That's with counts 1 and 2. Counts 3 and 4, they're 1 year, okay, I see what you did here, that's right. Yeah, on counts 3, she'll be sentenced to, she'll be adjudicated guilty. So that's a little bit of a change. Counts 1 and 2 is a withhold. Count 3, she's adjudicated guilty, sentenced to time served. Count 4, she'll be adjudicated guilty, sentenced to 11 months, 29 days probation, concurrent with counts 1 and 2, and sentenced and with the same terms and conditions. And counts 1 and 2, that 3-year probation is concurrent one with the other. Ma'am, you have the right to appeal the legality of the sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. You will need to be fingerprinted on these charges.
Your Honor, based on her being indigent, we request supervision.
Yeah, cost of supervision will be waived. I think that was part of the plea, and I forgot to announce it.
Thank you.
Sir. Well, that takes care of the 1:30 docket. Anyone here for the 2 o'clock docket that we can start it, or no one's here yet?
Your Honor, I don't think I have anything for 2 o'clock. May I excuse?
Sure. It's good seeing you again, Mr. Williams.
Good seeing you again, too, Judge.
I don't have anything either, Your Honor.
Okay.
Your Honor, there was a hearing for Stephen Jamison, and I believe the notice of cancellation of that hearing was filed 2 days ago. But he is off your afternoon docket, or should be.
I don't have them on the docket.
Okay.
The only 3 I've got for 2 o'clock is Lovejoy Pontio, Robert Neidner, and Dwayne Moore.
Thank you, Judge.
Judge, Dwayne Moore, there was a notice of cancellation of hearing filed this morning by Mr. Powell. So that will be canceled.
So Moore is off the docket, too.
Yes, sir.
Well, we'll take a short recess till 2 o'clock. We'll be in recess until 2 o'clock then.
Rise, please.
Are you ready? Oh,
It's just recess.
That's right.
Yeah.
I looked over there.
Yeah.
All right. We're ready to proceed on this case. Lovejoy Ponthio, is that pronounced right?
I'm sorry?
I pronounced that right?
Yes, sir.
Okay. Case number is 2020-523. And just for the record, this here on a motion to withdraw the plea agreement, or motion to withdraw her plea, which she filed pro se on February the 13th of 2022. And it was e-filed, and it was filed with the clerk on February, she wrote it, it stated February 13th, it was filed with the clerk February 17th. Judgment and sentence was entered on February the 10th.
Yes, sir.
So we're talking about a motion to withdraw the plea subsequent to sentence.
Yes, sir.
Everyone agree on that?
Yes, Your Honor.
Okay. I'm ready.
Judge, I'd call my client.
All right, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give would be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Would you please state your name for the record?
My name is Lovejoy Ponthia.
And Anthea, you hand-wrote this motion to withdraw your plea. And as the court indicated, you signed it, or you dated it February 13th, and then it got filed with the clerk on the 17th of February.
Yes, sir.
Is that correct?
Yes, sir.
Could you just basically tell the judge why you want to withdraw your plea?
I wanted to withdraw my plea because I felt like I wasn't properly represented by the counsel that I had. My family, my dad had just died, and they told my family that I've always wanted to go to trial. I told them from the get-go I wanted to go to trial. I tried to fire them before, even before this, and they talked me into letting them represent me. And so when it came down to it, my father had just died. They told my family that I would get 60 years if I didn't sign a 30-year plea. I chose not to go show up to the visits because I did not want to sign this plea. They gave me like a few days. I signed the plea in court because my family begged me to. I never wanted to sign the plea. I just felt like I wasn't properly represented, and I had nobody had my back, so I just broke and signed it. I really feel like I know I wanted to go to trial. I just feel like I was not represented properly by my lawyers to begin with.
You're asking the court to allow you to withdraw the plea, and so the matter could then be set for trial?
Yes, sir.
Ms. Ponthio, you're not denying that you signed the plea form, correct?
I'm not denying that I'm not denying that. I am saying that I signed it in court under duress, not really wanting to.
What do you mean you were under duress? Describe what you mean by that.
Like, I was pretty much told that I have like so many days to do it. It was on the docket for just a few amount of days. That my family was told that I was going to get 60 years or whatever if I didn't sign this plea. My family cried, begged me to do it. I told them I did not want to do it. I told my lawyers I never wanted to do it and that I wanted to go to trial to begin with.
You didn't sign the plea form on accident, right? You didn't
No.
accidentally slip and sign your signature, correct?
No, ma'am, I did
Okay.
not.
You weren't under the influence of any drugs, alcohol, or medication that day, correct? What prejudice have you received by entering the plea?
I don't even know what that means.
Okay. What, have you received a manifest of injustice? Okay. You knew that you were being charged with second-degree murder with a firearm, correct?
Yes, but it.
Just a yes or no? Okay. And you knew that you were a prison releasee reoffender, correct? Okay, and you knew that the PRR, prison releasee that status meant that if you were convicted, you would actually be sentenced to a mandatory life in prison if found guilty of second-degree murder with a firearm, correct? Okay, and you also knew that you were facing several drug trafficking charges with 15-year minimum mandatories, correct? Okay, and you knew those trafficking charges were punishable by up to 30 years in prison each, is that correct?
Yes, ma'am.
And the possession of a firearm by a convicted felon, that had a 3-year min followed by 15. So you're all aware of that, correct?
I'm aware of that.
And your attorney informed you of all of those potential sentences, correct?
No.
Okay.
They just told me that y'all had a lot of evidence on me. They never showed me any evidence on me. They never came to me face-to-face and told me anything that I could do. I told them I wanted to go to trial so I could tell Tyler's family exactly what happened. And
Your attorneys made you aware that there was a 30-year plea offer on the table with no minimum mandatory, correct?
yes,
And that's the offer
I
that
had
you
a
ended up
few
signing,
days.
correct?
with a few days to think about it.
Okay, a few days. Were you told by your defense counsel of the offer on February 1st of 2022? Well, you were told the offer on January 21st
My
of
lawyers
2022.
visited me like twice over Vizzo.
So Mr. Flaherty represented on the record, which is in the transcript of page 4, that he discussed with you on the 21st of January, the plea offer, and that he tried to schedule follow-up visits on the 25th of January, 26th, 20, and 28th, and you didn't appear for.
I didn't
You
appear
in-
for them because I told them that I did not.
Right. You indicated on the record during your plea colloquy that that information that he has represented on the record was correct. So he in fact did discuss with you the offer on January 21st of 2022, correct?
He told me about the offer, yes.
And then he also spoke with you on February 1st, which he put on the record that you did not dispute, correct?
No, I called my family and they begged me to do it, and I told my family, I didn't tell them, I told my family to call them and say.
Ms. Ponto, you indicated that everything that your attorney during the plea colloquy was correct, right? So he listed that he had a final conversation with you on February 1st of 2022, which was a week before the plea. Is that correct?
No, we didn't even, he told me he would meet me in the courtroom on the day that I come to court.
So it's your testimony here today that he never spoke with you on February 1st, 2022?
He told me of the plea offer. I didn't agree to it.
He told you multiple times of the plea offer, correct?
No, ma'am. He told me once, and then I discussed it with my family.
And you actually had several discussions with your attorney regarding the plea offers because the first plea offer from the state you declined, correct?
For 25 years, yeah, like a year before.
And then he got a different offer for you, correct?
It's the
Which
two.
included dropping the drug charges, the possession of firearm charges, and dropping the minimum mandatories and the PRR
Yes, ma'am, I
enhancement.
understand that. My
That's
point,
just a yes or a no. He got you a different offer, correct? Yes? Yes. Okay. Now, did any of your defense counsel threaten you and make you sign this plea?
they threatened me with more time.
Okay, explain what you mean by that.
They basically said that, the DA said if I don't sign this 30-year plea, that they were going to give me 60 years. And I said, they can give me 1,000 years. I want to go to trial.
And it's your testimony here today that you signed the plea form, you went back to the jail, and you realized you'd made a mistake, right?
No, when I got here, they didn't let me know that Tyler's family was going to be here. And the letter that Tyler's mom read on the stand made me understand that I wanted to withdraw my plea and tell the story about what would happen.
During the plea colloquy, Judge Ketchel,
He
he
did
asked
ask
you.
me, yes.
Ma'am, if I may ask the question before you answer, please. The day that you entered a plea and was sentenced, during the plea colloquy, you heard your attorney outline the conversations with you, and Judge Ketchel asked you if everything that your attorney said was accurate, and your answer was yes. Is that correct?
Yes,
Okay. And Judge Ketchel also asked you during the plea colloquy if the plea and sentence agreement is what you agreed to, and your answer was yes, correct? Then Judge Ketchel asked you if you had gone over the plea form and sentencing agreement in some detail with him, and you answered, quote, "Yes, sir," correct? So you indicated under oath during the plea colloquy that you in fact had an opportunity to go over the plea with your counsel, correct?
when he stopped the court and we went that.
Yes or no? Yes. Okay. In the middle of the plea, you were given an opportunity to go back with defense counsel and review the plea form in its entirety whenever you indicated to the court you had not read the plea form verbatim, correct? So you went back with your defense counsel and you reviewed the plea form verbatim, correct?
Well, basically, they just told me nothing was going to change. We'll just sit here for a minute and we'll go back into the courtroom.
That's what they told you?
Yes.
Okay. So you didn't review the plea form?
I knew that I knew that they weren't even trying to help me to begin with.
Then why did you indicate to the court that you had reviewed it?
Because I felt like nobody had my back.
You also told the judge during the plea colloquy that you were waiving your right to a trial, and you understood that you were waiving that right, correct?
I did just now.
And when Judge Ketchel informed you of your constitutional rights and you waived those rights, he asked you, quote, "Is this what you want to do here today?" You're clear about that. And your answer was, "Yes, sir." Correct? And you have a high school degree, correct? You know how to read, write? You understand English?
No.
And you knew the plea that you were signing at the moment was for 30 years in prison, right?
I did.
No one tricked you into accepting this plea on that day, correct?
On that day?
Right.
No, but
Okay.
into it, yes.
I don't have any other questions, Judge.
Redirect, if any.
Ma'am, is there anything else that's not been talked about that you want the court to know as the court decides whether or not to allow you to withdraw the plea?
No, basically, I want my fair right to let everybody know what happened. Yes, I was arrested under second-degree murder, but it was definitely not murder, and I want it proven that it wasn't, and that it was always, I guess it's going to be manslaughter. So it's not really a lesser charge of something that it already is. And as far as the drugs, I don't even know anything. I don't know. I've never even had counsel to even go over anything like that.
Your Honor, I think those are the questions that I need to cover.
Witnesses?
I don't have any.
State?
Judge, I do have a witness, Mr. Tim Flaherty. Prefer him at the podium or the witness stand, Your Honor?
Put him in the witness stand. Your expert, sir. Sir, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir.
May I proceed? Good afternoon, sir. What's your name, if you could please state and spell your first and last name for the record?
My name is Tim Flaherty. Last name is spelled F as in Frank, Laherty.
What's your occupation, sir?
I'm an attorney,
How long have you been practicing law in Florida?
21 years.
All right. Do you have any specific area of practice?
Yeah, we limit our practice exclusively to criminal defense.
Okay. Have you had the opportunity to represent defendants in homicide cases before in your career?
Yes,
Approximately how many times?
this was our second.
Okay. You were representing the defendant for this case, correct?
Yes,
All right. And you were actually representing her pro bono, is that
Yes.
right? Okay. Are you aware of the allegations the defendant set forth in her motion to withdraw plea?
yes, I am.
Okay. And you were given a plea offer in this case from the state in early 2021, is that correct?
Yeah, I believe it was January of 2021 for 25 years.
And that offer actually included minimum mandatory sentencing, correct?
That's my recollection, yes.
And you were informed also that the defendant was a prison releasee reoffender subject to minimum mandatory enhancements.
Yeah, my understanding was that if she had been convicted at trial, she would have faced a mandatory life sentence.
You indicated on the record that you discussed the case and the plea offer with the defendant on March 23rd and 29th and May 5th of 2021 during the plea colloquy. Is that correct?
Yes,
You also spoke with her family about the plea offer on April 20th, April 22nd of 2021, and January 28th of 2022. Is that correct?
yes.
Okay. Once you received the state's new plea offer that did not involve minimum mandatories or a prison releasee reoffender enhancement status, did you speak with the defendant again about that offer?
Yes, I did. Along with my partner, Brandy Merrifield, we discussed the new offer that had been made in the case, which to my recollection was 30 years Department of Corrections. The cases that would have triggered a mandatory minimum sentence would have been dismissed as part of the plea, and the state had agreed not to seek PRR enhancements as part of the plea.
And did you actively discuss that offer and the case with the defendant throughout your representation?
And if I could just expand on that a little bit.
Please.
Obviously, anytime we undertake the representation in a criminal case, decisions and thoughts have to be made about entering a plea in a case versus going to trial, and that includes evaluating strengths and weaknesses of the case. One of the allegations that Ms. Pointhill made is that we never engaged services of any expert witnesses. That's factually untrue. We had actually engaged the services of a firearm expert, a forensic crime scene analyst, as well as a mental health specialist. Consultations with those 3 experts helped inform the advice that we gave Ms. Pointhill, which was that we did not feel it would be likely that she would succeed at trial. She was told every time we spoke to her that she had every right to go to trial, but that it was not our advice to go to trial. Based on the fact that regardless of what happened in the murder case, minimum mandatory sentences were waiting. And my recollection is that was at least 30 years of minimum mandatory sentences along with the PRR. And as Ms. Pointhill just said a few minutes ago, she never saw this case as a murder case. And that was actually addressed in our plea colloquy. Ms. Pointhill had told us from day one she did not want to plead to murder. So when we entered the plea, we actually addressed that on the record, that she was pleading to manslaughter because none of us felt like this was a murder case. This was a manslaughter case. And if this had only been a manslaughter case without any drugs found, we most likely would have gone to trial in the case. But the likelihood of conviction on the other charges made it impossible for us to recommend that she go to trial.
Did you conduct depositions in this case?
We did.
Okay. And did you explore all the possible defenses in this case despite there being a confession?
Yes.
Did you review the actual plea form that the defendant signed and executed on February 10th of 2022 with the defendant?
Yeah, and if I could expand on that just a bit. So Ms. Pointhill is correct that there was a break in the court proceeding because the morning of court, they didn't bring Ms. Pointhill to court until well after court had started. So while we had gone over the plea via a Zoom call, it was about 10:30 when they brought her to court. So we had to just orally talk to her about it, but she did not have a plea in her hands to read. So when the judge asked her the question, did you read the plea form, she truthfully answered no. And I believe, Ms. Glisson, you did point out that counsel has stated and has represented to the court that they read the plea to her verbatim, which we had. But in the abundance of caution, Judge Ketchel asked us to step outside and actually hand her the plea and let her read it. I'd also like to make one comment about what Ms. Pointhill said about that we just went in the back and said it's not going to matter anyway. That, again, is just simply factually untrue. My partner and I, Ms. Merrifield, went into the attorney-client room. We handed her a copy of the plea. We also had a copy of the plea, and we went over it line by line in detail to make sure that she had the opportunity to read, review, and ask questions about the plea.
Thank you. And you indicated during the plea colloquy that this is not a situation where the morning of court, prior to entering the plea and being sentenced, that Ms. Pointhill was presented with this plea offer. She was presented with this plea offer weeks in advance, correct?
No.
I don't remember the exact dates. It may not have been weeks, but it was at least more than a week. And it's interesting that Ms. Pointhill was saying that she didn't have a chance to discuss it, but there's also the issue of we attempted on multiple occasions to discuss it with her, and she refused to appear for the meetings. So that did lessen our ability to have 4 or 5 discussions about the plea because she simply didn't show up. But there were discussions about the plea both with her and with her family. And then on the morning of court, she was given the opportunity, both by us and by the judge, to either say, yes, I want to enter this plea, or no, I don't.
She was actually given 2 opportunities that morning, correct? Okay. When you reviewed the plea agreement with her the morning prior to court, did she have any questions?
Not to my recollection. I do remember that she had expressed surprise that the victim's family was there. Ms. Pointhill had always had an opinion that the victim's family would be on her side and that they would be sympathetic to her position. We had always told her that that was not our interpretation at all, that in their mind, she had killed their son. So it certainly would stand to reason that they would be in court and would not be supportive of her at her sentencing for the homicide of their child. While that may have been a surprise to her, it certainly wasn't a surprise to us.
Did you threaten the defendant to sign the plea form?
Absolutely not.
Did you make her any promises in order to get her to sign the plea form?
Other than the terms that are contained on the plea agreement, absolutely not.
Did you coerce her in any way?
Absolutely not.
Did you give her any mistaken advice as to what the sentence was going to be?
Absolutely not, and I certainly didn't say you will get X amount or you will get this amount. It's our job to tell a client what the maximum sentence that they could receive. In this case, there actually was a known sentence if she had been convicted because of the PRR enhancement,
Would have been life.
and that would have been a mandatory life sentence. But even if by some reason that didn't happen, she was facing at least 30 years of minimum mandatory with no gain time sentencing on the trafficking charges.
Did she indicate to you that this was the deal she wanted to take?
I don't want to characterize the words that she used, but she was made aware of the offer, of what her options were, and she did decide to orally and in writing sign the plea and enter the plea in front of the judge.
And is there anything else that you think the court should be aware of for purposes of today's motion to withdraw her plea?
Come in.
I tender the witness.
Curious question. When you said that y'all read her the plea agreement to begin with, because they got her to court like that, break, was she handed a copy of the plea agreement for her to then read herself before she went into the attorney? Or I guess the jail room?
My recollection would have been that during the break, we would have physically handed her the physical copy of the plea form. But prior to that, we had not physically handed her a piece of paper.
How long was the break?
5 to 10, maybe 10 minutes, 15 minutes.
Those are my questions, Judge.
Be direct.
No other questions, Judge?
Next witness.
No other witness from the state.
Judge, I think she's willing to testify as to what her perception of his testimony was and where she differs.
All right, you're still under oath, ma'am.
So you've heard what Mr. Flattery had to say, right?
Yes, sir.
Tell us what you disagree with.
That he did, it's got to be recorded. All this stuff has got to be recorded. And he did somebody told my family they were going to give me that much time. My family cried to me on the phone and begged me to take this, pushed me into it, even though I begged my family not to do it, that I wanted to take it to trial. They did not give me ample amount of time to do it. Told me that there was a 30-year plea and that they would discuss it with me when I came to court, and they did not. We just came into the courtroom with it, and I signed it in front of the judge, and then the judge, that is just... I don't know where to go. I don't know where to go from here.
So you disagree with his testimony about how the plea was discussed and what have you?
Yes.
Is that right?
Yes, sir.
No questions.
Any argument?
Judge, I think my client's position is that he didn't want to do the deal and felt like she had no choice. Prior to that, leading up to it, I think she's written motion that she didn't feel that he was getting enough contact with her attorneys to make an informed decision.
Judge, I don't get to say this very often, but this is the defense's burden. And the defendant in this case has filed her motion, and the only possible avenue for her to relieve the request that she's submitted is to file it, or to request it under Rule 9.140 B2A 2C, which states that the defendant who pleads guilty or no contest may directly appeal upon limited grounds. And here, the defendant is arguing that she meets one of those grounds, which is an involuntary plea. Whereas the court typically enjoys broad discretion as to motions to withdraw a plea prior to sentencing, the court does not get to enjoy broad discretion as to motions filed after sentencing, and that is in Griffin v. State Supreme Court Case 114 Southern 3rd 890. Additionally, there's an extensive line of case law that says where a motion to withdraw plea occurring after sentencing, the defendant has the burden of proving that a manifest injustice has occurred, which is a more stringent standard than a motion to withdraw a plea before sentencing. The burden falls on the defendant to prove the withdrawal is necessary to correct the manifest injustice, and such proof must be more than mere allegations. So stopping at that, I would submit that we have not, defense has not put on any type of proof that rises to the level that they need to meet their burden. There's been no mention of any type of manifest injustice or prejudice by the defendant receiving a sentence that's significantly lower than what she was facing had she not accepted this plea. Absent coercion, mistake, or misadvice, the defendants may not renege on plea agreements on the basis that they have miscalculated their risks and benefits or have belatedly discovered a new defense. Here we heard testimony that there was no coercion, there was no mistake or misadvice. All we have here is allegations from Ms. Ponthu that has no supporting proof. Finally, the defendant has indicated on the record and here in court today that she did indicate, yes, this was her agreement, yes, this is what she wished to do, yes, she wanted to waive her right to trial and accept the state's plea. In exchange, she had 4 minimum mandatory sentences dismissed against her, and she also received a second-degree murder with a firearm charge, bumped down to a lesser included of manslaughter with a firearm. Based on the fact that the burden is on the defendant, we don't have any proof that would be able to overcome that the defendant's burden. And here, the state's requesting that the motion to withdraw a plea be denied based on that.
I'm satisfied from hearing the testimony of Mr. Flaherty, and also I read the transcripts. I know I wasn't the sentencing judge, but I did read the transcripts of what occurred on the sentencing date. And I'm satisfied, ma'am, that at the time you entered your plea, it was voluntarily entered. You were not under duress, and there's no evidence of any manifest injustice here. I suspect what happened was that sometime after you entered your plea, you may have changed your mind, but that is not grounds to withdraw a plea that was previously voluntarily and intelligently entered after you've had the benefit of advice of counsel. And I'm satisfied that you were properly advised. You made a decision, and the decision at the time was voluntary, and therefore I'm going to deny the motion to withdraw her previously entered plea. I'll ask the state to prepare that order.
Thank you, Judge.
And if you'll have Edna put it in my file, I can sign it electronically.
I will, Your Honor. And that's all I have before the court. May I be excused?
Yes, ma'am.
Thank you.
Your Honor, thank you. That's all I've got. May I be excused?
Yes, sir. Thank you. My next case is Robert Neidner.
Good afternoon, Your Honor. Sean LaPella for the defense, along with Dave Rare, co-counsel.
It's a discovery issue, is that right?
Yes, it's 22 CF 977. For the record, Mr. Neidner has waived his appearance for today, and it is a discovery issue in regard to, this is one of those chatter sexting type of cases where there's a profile set up and then contact is made with the defendant, or the defendant makes contact with the chatter or the profile person, and there's communication there. And basically what we're looking at is we want to have access to the phone records from the chats that occurred between our client and law enforcement. And we want to have access to the data file, the digital data file, so we can inspect it and determine that all the communications are intact and that they're there. The reason to believe that there's additional communications on that data file that were not included in the state's constructed spreadsheet document that they made subsequently.
Your Honor, first of all, if Mr. LaPella or Mr. Rare is aware of any additional information that their client might be in possession that indicates that they may not be complete chats, we'd ask that be provided in reciprocal discovery. Now, as to his request, these particular chats were captured in a law enforcement application called Calio. on the chatter's phone. The Calio or Calio app records everything, and that is then maintained by Calio. The printout thereof we have provided to Mr. LaPella in discovery, so he has everything we have. If he believes there is more than that on that particular app on the Calio, then that would have to be obtained through a subpoena directly to the company. At this point, we've provided everything that we have. We haven't denied him access to anything that we have. So absent them issuing a subpoena to the company, we'd be glad to provide the point of contact for that. We would have no way of getting that additional information if it exists. We don't believe it does because we've downloaded everything and provided it.
What leads you to believe the state hasn't provided everything that is in their possession?
Well, first of all, Your Honor, what they just mentioned about this Calio app, which we don't think is subject to subpoena discovery, should be just discoverable, and the state should provide it. It's within their category of knowledge, and it's imputed to their knowledge in the case. So that's the first thing. The second thing is that in the actual chats themselves, normally what we see in these types of cases are a situation where there's closure and there's an indication that there's going to be a traveling episode where the person's going to commit to doing an act at a location with the chatter, and that's how these things end. In this particular case, the chat was kind of somewhat abruptly ended, and there's no indication that there's any follow-up, and I do have reason to believe that there may be more additional conversations between the chatter and our client, Mr. Niedner. So we'd like the opportunity to inspect the data file and from the Calio app or from the phone itself preferably to be able to determine that.
Just, Your Honor, that we have provided what we have from the Calio download. If there's something more that Mr. LaPella has, certainly that leads him to believe beyond that, we'd ask that be provided. Abrupt ends to chats are not out of the ordinary, Your Honor. I've done many of these operations. People walk away for different reasons. So all I can say is we provided what we have. Anything further, if he believes there's more than that, it's going to have to come from the company itself. We've given him what we have.
Well, is the data that he's talking about, is that in your possession?
Yes, and that's what we provided.
And that's what you provide?
Yes, sir.
You provide everything you have?
Yes, sir.
I would dispute that, Judge.
And additionally, Your Honor, there were some questions that came up at the deposition that were not able to be answered by the investigating officer that would be more within the purview of the individual that was running the op, Investigator Evans, and we've added him as a witness so that Mr. LaPella can also take his deposition and clarify anything further if there's any other questions as to who has what. But what I can tell the court is we have provided what we have.
The counsel's an officer of the court. She says she provided everything that you have, that she has in her possession. I'm going to deny the motion to compel without prejudice to you to issue a subpoena against the...
Okay, and I would need to have the information of what this company is and their contact information.
Well,
We can provide that.
provide that, can you not?
Yes, we can, Your Honor, because that would be something we would use if we needed it, so we will certainly provide that to him.
And
No problem.
And to clarify, Your Honor, is the court also denying our ability to inspect the phone that was used in the case and be able to look and see if there's chats on that phone? Because I think we are entitled to inspect the phone.
Whose possession is the phone?
Your Honor, no, just to clarify, no one's denied him access to that phone. We were attempting to determine if the phones remained here. The chatter in this particular operation was from out of county. So we were trying to determine if she had used her own phone or if she'd used one of ours. If she'd used one of ours, then she leaves it with us. In speaking with the officer in the case, we determined that it's very likely she took it with her, so we will follow up on that. If she has that phone, we certainly can make that available. Not an issue. So we're not denying it. It was just a question of who has the phone. We don't have it.
Well, okay. Just for my own understanding, would that chat be, is that forever recorded on the phone, or?
Your Honor, our understanding is, and this is something that we would verify once we get if she still has the phone and it hasn't been deleted, because generally what they do is it gets uploaded to the Calio, to the program, and then it gets deleted off the phone. That's why the file remains resident with the company. So that's what we suspect would be the situation, but I can get the phone and we can verify that.
So this is a special phone. It's not your typical cell phone.
No, but they're apps that are on there for the purposes
And
of,
those apps record the conversation.
yes, sir, they do. That's my understanding, yes, sir.
And I think they're entitled to that. I'm going to deny the motion to compel. They've indicated they've given you everything they have, but I will require you to provide the phone if you get that.
Access to it, yes, Your Honor, not the actual phone. Yes, sir.
And also provide the information of the company
Palio.
that owns or runs the app so they can file the subpoena that they need.
Certainly not a problem. We can do that.
And Your Honor, would the court also in that order put in language that would authorize our office, because Calio may have a contract with the state attorney or with the law enforcement, but to put in the order that we have express authorization to obtain the data file as submitted by the state or the information from Calio in its full package.
I think the best way to do that is to file your subpoena and then let them file an objection if they have it, and then we can have a hearing on that. I don't want to prejudge that issue if they have some valid reason or some exception, to providing it. Proprietary or not, I don't know. But they object to it, then you can file,
And Judge, if I could have one final thing on the record. We do anticipate, if the state is unwilling to obtain the data themselves and that their interest is to supply, at trial, for instance, to supply evidence in front of a jury of a document spreadsheet with texts or chats that are typed into a spreadsheet, that's a hearsay document. We're going to be objecting to its use and employment during a trial, that they would have to provide the actual evidence of the actual text messages in the chats, and a hearsay document is going to be insufficient to do so, and that we're not going to be in a position where we're going to be able to supply the state with evidence that they're going to be able to use at trial from the Calio company, because I would assume, my understanding is that they would have needed that documentation, or not just the documentation, but the actual data to provide it for trial and have it, so it's not hearsay. But I just want to make that clear that we're going to be objecting to them using a hearsay document spreadsheet for use at trial.
that's your right to
Okay.
object to any evidence that's.
Okay, we're not waiving that. We're not waiving that, even if the states acknowledge they're not going to seek it.
Appropriate time. I mean, I don't know what they're intending on.
We understand the rules of evidence, Your Honor. Not a problem.
Yeah.
Anything else?
Out from the state, Mr. LaPella?
No, Judge.
All right, thanks, folks.
Thank you, Judge. And Judge, we have nothing further either. May I be excused?
In fact, I think that takes care of the docket, doesn't it?
Then we may all.
Yes.
One more?
Who was that?
Your Honor, if I may, Austin Foreman was originally scheduled for today, but he was not transported until late in the day yesterday. So Ms. Flowers and I had thought that he was already removed from today's docket. We just need to put him on another miscellaneous docket, so if we could perhaps advise him, he'll be back on the docket on the 28th.
The 28th or the 29th on the miscellaneous docket?
Whichever is the miscellaneous docket, please.
You've got pretrial dockets on the 28th for inmates, then you've got a miscellaneous docket on the 29th.
We'd ask for the 29th, Your Honor, please.
All right, sir, you want to know your next court date?
Yes.
Be December 29th at 9 a.m.
Okay. Question, do I have to stay in county, or can I go back to DOC?
Well, who's your attorney?
I believe Flowers?
Mr. Flowers?
Yes.
Ms. Flowers? Every day he's out of state prison, he doesn't get credit. I don't know, she may want you here, sir, to communicate with you.
Yes.
Wish she was here. Based. I don't see any hearing dates before the 29th. What did you say he was going to be here for?
Judge, he's before the court on a motion to withdraw his plea after sentencing. Sentenced, I believe, was the beginning of this year.
Yes.
He's been
Have you had a chance to meet with, don't tell me what you talked about, but have you had a chance to meet with Ms. Flowers yet?
No, sir.
You haven't? Let's keep him here then. I'm going to order that he remain in the county jail until 29th, unless Ms. Flowers says that he can be sent back to DOC. Because every day he's up here, he's not going to get credit for time.
I have a few questions.
You really need to talk to your attorney, sir. I think that's the best way to do it.
All right.
Procedurally, I can handle those issues, but substantive matters, you really need to talk. All right, okay, that's all. Any other matters for this afternoon? All right, we're adjourned. Thank you all for your help, I appreciate it. Y'all have nice holidays.